A very good afternoon to you. Now, as we commemorate Women's Month, we take an in-depth look at some of the challenges that women face on a daily basis. Now, child maintenance remains a thorny issue for many women. And the question we're asking is there a need to overhaul the maintenance laws and how exactly do they operate? Joining us in studio today is Mr. Dennis Masango, a lawyer from Legal Aid South Africa. Thank you so much for your time this afternoon, sir.
Thank you very much, and good afternoon to the viewers at home.
So when we talk about maintenance, what exactly are we talking about as far as the definition of the act?
Maintenance, it's a provision of support to the children for their various needs. Their needs can take the form of providing shelter to the children, providing medication, providing education, and providing food, and even clothing. And that stems from the constitutional obligation. If you look at Section 28 that talks about the Bill of Rights, it emphasizes what is required in terms of providing for the children. And you look, it's extended also in terms of the Children's Act. It shows that children should be provided with certain basic needs so that they can be able to develop. Basically, maintenance is about that. If you bring somebody into this world, you must make sure that that particular child is taken care of on all the aspects that I've mentioned. Provision of shelter, which is important, and food, which is important, as I've stated earlier on, and education, because the needs, mental needs and development of a child are also important.
And who is responsible for the maintenance of a child?
Well, the parents of the children are responsible for the maintenance of the child. Both parents are responsible for the maintenance of the child, whether they are married, whether they are divorced, whether they live in partnership, or they are separated. They have an obligation in terms of the law, a legal duty to maintain the child, to make provisions for the needs of the child, so that the child can grow up. Even though the parents are separate or the parents are together, it's immaterial. What is important, the needs of the children.
What I found quite interesting is that it states here that grandparents as well are also responsible for the maintenance. I mean, how accurate is that, and to what extent are they responsible, should they be?
Well, obviously, if the actual parents of the child are not in a position to maintain, and the grandparents have means to come on board and assist, they are enjoined and compelled by the court to assist the parents, the actual parents, to maintain for the children, the grandchild, basically. So the law imposes an obligation on grandparents. Obviously, there's what we call a means test. Are the grandparents able to take over the duties of the parents? Because the grandchild or the child cannot be left neglected in terms of the needs that he or she needs on a daily basis.
So you're saying here that the responsibilities, as far as the grandparents are concerned, are not just, good-naturedly type of responsibilities, but they're actually legally compelled to also support should both the parents not be able to?
Definitely, it's a legal obligation. It's not that something that...
It's not an act of goodwill.
Comes as an act of goodwill, or it's an ex gratia, basically, a system that comes of the grandparents. It's a legal obligation in the event, there's a caveat that, in the event that the parents are unable to support the children.
Now, let's look at situations where perhaps a woman and her partner are divorced, and let's say the man is not paying the maintenance, for the child. What are the type of steps that women have within their arsenal in order to ensure that maintenance is paid for their children?
It's a very good question, and we have courts in our land. We've got the magistrates' courts, we have the high courts. If you feel that the partner, whether the husband or the partner, does not come on board in terms of maintaining the child, the last step, because it's a way of negotiating, but the last step, if the partner does not come on board, the other party, which is the woman in this particular sector, because most of the time they find themselves in this situation, they have to go to the maintenance court. In the area in which they reside or in the area where they work, the nearest magistrates court, there are civil clerks there where they can lay a complaint. So there are processes that they will assist. Obviously, there are documentation that the mother or the woman has to bring to court, for example, the needs analysis of her requirements in terms of maintaining the child. What are the actual expenses, and everything needs to be tabulated. What are the needs of the child, schooling, what we mentioned earlier on, and compound it into a single amount. Then the court will look into that means. What they will need, the court then will issue what we call a summons to the respondent, which is the other party, to come and appear in court on a specific date where the issues will be ventilated. If the father of the child or the man does not dispute whatever amount the woman requested or the mother requested, then the matter will be settled. But if there are issues, then it will be referred to the presiding officer, which is the magistrate court, then who will interrogate the father as to on what basis are you refusing that. He might say, the amount is too much, these are my living expenses, I cannot afford. Then the magistrate, based on his discretionary powers and looking upon the means of the mother and the means of the father, can make a determination as to what is acceptable for the maintenance and support of the child.
Does it matter who the child lives with?
Well, it doesn't matter. There's what we call a legal guardian. You know, sometimes due to certain issues, the mother has passed away, and the child lives with the grandmother, who becomes a guardian of the child. The grandmother can therefore goes to the maintenance court, as long as the child has not reached what we call a majority age, which is 18 years old. Then the grandmother, who is the official guardian of the child, can then approach the courts and say, I'm living with this child, the mother has passed away possibly, and I'm taking care of them. Or sometimes the foster parent can also do that. You know, whoever is a legal guardian of the child at that particular juncture.
Now, you know, things have changed and dynamics have changed, and you might find a situation where perhaps it is the man, the father, who is the primary caregiver for the child. In that case, are you experiencing instances where men also are claiming maintenance of the children from women, or has that dynamic not quite become a reality in South Africa yet?
Well, we do experience such situation because you understand that the Constitution obviously drives that everyone is equal before the law and there's gender parity. So therefore, if what would stop the other party, if the other party is financially well off and the primary caregiver is the man, he's entitled, if possibly he cannot be able on himself take care of the child financially, possibly needs assistance if he's not working. If he's working, his financial circumstances don't allow him to maintain the child as it needs to be required. But the point is, it does not discriminate. Whoever feels that I'm with the child and it's not enough can approach the court and say, Mrs. So-and-so is not supporting. I need the court to assist. I've been talking to her. I've been persuading her. I've been negotiating with her, at least to put something so that it is for the best. Remember, initially, the primary concern of the Constitution and the High Court is that what is in the best interest of the child? Mm-hmm. That's the guiding principle. If the court finds that this is not in the best interest of the child, then the court will not make any determination.
Now, what happens in a situation where, because according to the rules and the legislation, the provision is for proper education, proper maintenance, but proper is quite a subjective term to be used, because what may be proper for you may not be proper for me. So how is the entire extent of the maintenance actually calculated, even as far as living standards are concerned? Let's say the one party wants to take the child to a private school, and the opposing party says, I cannot afford that private school. How are those type of issues of expectations monitored and regulated?
That's why we have presiding officers, because both parties, they will make their submissions and bringing proof as to their standard of living. So if the standard of living of one party is very high, then the court will look into the financial history and the circumstances. And the court will say, no, you can afford to pay. What is proper, obviously, is in the discretion of the court. Looking at the documents provided and looking at the submissions made by both parties. If the other party is living a good life, for example, we had circumstances where a young man who has recently qualified as an engineer, then he works, he gets a lot of money, and then he drives fast cars, but he's failing to maintain and the mother of the child say, this person is earning around 100,000, but is giving me 1,000 rands. How am I going to maintain the child? Then the court will say, can even come to a position say, you must sell the car. You must sell your investments. You must sell your policies. Because at the end of the day, we need that money to support the child. If your living expenses are high, you must reduce them. Because the primary important person here is who? The child. And I must act as a price-setting officer on the best, what is in the best interest of the child. If you can afford 10,000, and I'm looking at the documents, I'm going to make that determination that the child must be maintained. Sometimes it happens when parties have separated, they've divorced, and they were living a lifestyle which is very high, and they divorced. And you cannot, unfortunately, change the child's lifestyle, which is accustomed to, and say, no, I'm not going to pay this. If you can afford, the court will say, no, no, no. Don't reduce the lifestyle of the child because the parties have separated. This has nothing to do with parents. This is something to do with the child.
Now, let's look at the different options that this monthly maintenance can be paid. I guess it can be paid directly to the party that has custody of the child or the primary caregiver.
Yes.
But then also sometimes employees or rather the employment party can also come into the dynamic.
Definitely, that is the last option because of recalcitrant fathers who don't want to pay. Sometimes they make the life of some women miserable. They will skip payment, they will pay half, sometimes they don't pay. And the woman will be left with unpaid bills, and the schools will be calling her, and everything, it frustrates her. Then she goes back to the court. Must go back to the court and say, I want this money to be garnished, that's the word we use, to be taken from the salary of the respondent so that I don't have any problems. And I don't want the money. Sometimes the money can be deposited into the account of the nearest Department of Justice, which would be the magistrate's court. Sometimes it takes time to retrieve that money. The best available resources is for the money from the account at work to the applicant's or the woman's bank account, so that you can be able to utilize it.
There's no interference there. And what about backdated maintenance? Can you start claiming, let's say they haven't been paying maintenance for 5 years. Can you claim for the maintenance for the past 5 years as well as maintenance moving forward?
Yes, you can, as long as there was an order of the court. For example, you see some women and say, I've been raising the child alone. You were not there for requests. I'm going to claim back from when the child was still an infant. Now the child is 17 years old. I'm going to need it. But that won't be possible unless the court made an order 5 years ago and you fail to comply with the order. Then that's what we call area maintenance. Then you are able to go back to the courts.
Now, one more question, before we go to our break. What happens in a situation before a divorce has been settled to ensure that the children are still being maintained even while the final settlement, before the final settlement has been made?
Well, there's what we call, in the process of the divorce, it's maintenance pendentality in legal language. It means maintenance pending the finalization of the litigation. It's contained in Section 43 of the High Court, where they make an application before the process, because sometimes the legal process takes time, but the children needs to be taken care of. You can apply to court for the maintenance to be paid pending finalization of the divorce.
So provision has been made under Section 43.
Definitely.
Thank you so much for your time and for your legal advice.
Thank you very much for the opportunity.
We'll have a quick ad break and our news continues just after this. We have been in conversation with Mr. Dennis Masango, a lawyer from Legal Aid, just looking at how maintenance and issues of maintenance can be sorted out specifically in regard to children.